should not be allowed.
Allow me to connect it to the very famous considerations that you then gave out as you were exiting the stage as CJ. And you said very clearly that Parliament ought to be dissolved if, on anything, that they were not able to attain the 2/3 gender rule. And you said, in this case, the executive has only one job to do: vacate Parliament, right? Now, you've been hanging on to the threads of the Constitution, and we see things over and over and over again that legal minds, as well as judicial officers, would say that this flies in the face of the Constitution. You've just mentioned public participation. When we talk about presidential aspirants, it's not just somebody wanting to be president, but it is somebody who is involved in and engaged in the activities of constitutionalism.
Exactly.
The other day, there was a court ruling. I'm not even going to talk about the individual, but I'm going to talk about the processes of constitutionalism, where from the mouth of judges, it was clear that there was an aspect of constitutionalism that was not adhered to. But what they did was compensate for it. What should be done as per interpretation when you see that an aspect of the Constitution has not been adhered to? Do you say, let's go and do it again? Or do you put some money at it? Coming also from a CJ who nullified an entire election based on procedure. What should happen when the Constitution has not been followed?
Thank you. You brought in here two issues.
Yes.
The first one is my advisory to the President to dissolve Parliament under Article 261. Quite a number of people criticized my decision, but I want you to look at it this way. This was one of the transitional provisions, as we call it, that required Parliament to enact legislation to actualize the 2/3 gender rule. Parliament was given 5 years to do that. At the time the application came to me, it was over 9 years. And what the evidence I had before me was what I call tokenish kind of thing. Parliament was not serious. There were bills. When it is supposed to sit, they were saying we don't have quorum, we don't have this, and the act went on. And the provisions of Article 261 were mandatory. There were, I think, 4 court orders. Directing Parliament to pass that legislation. Now, recently, a decision of the High Court declared my advisory unconstitutional on the ground that the order of the court, the High Court, before the matter came to me, had not been transmitted to the speakers of the National Assembly and the Attorney General. I looked at that and I was asking myself, the issue was that this order was not transmitted to Parliament. What is transmission? What is the purpose of transmission? The purpose of transmission is to bring it to the attention of Parliament that this order has been passed. The order was passed in the presence of the lawyers of Parliament.
Yes.
Now, that's not all. Parliament actually appealed against that order. And the Court of Appeal dismissed its appeal. Then you now say, because the order was not transmitted as the Constitution says. I mean, the Constitution, you have to read the spirit of the Constitution. What is the purpose? The same Constitution says that substantive justice should not be undermined by procedural technicalities Article 159(2) D of the Constitution. So my understanding is sometimes courts should also be careful not to, in fact, almost. I don't want to use the word undermine the constitutional provisions, but they should read the Constitution as a whole and see that the substantive justice in this case required the requirement of substantive justice in this case is to bring it to the attention of Parliament, so that Parliament is not blamed for what it doesn't know. Yes. Now coming to the other issues about violation of constitutional provisions. I don't know which case you had in mind.
Well, let's go with the Gachagua ruling that went out on Tuesday. On Monday, actually.
Yes. I saw that judgment, and a lot of things came to my mind. I was asking myself a lot of things. Under Article 225, I believe, is it 2C? The right to a fair hearing is sacrosanct. What does that mean? Actually, the provisions in the Constitution, the wording in the Constitution is that it cannot be limited. What is the message from here? It is the importance of the right to a hearing, to a fair hearing. The court finds that Honorable Gachagua was not given a fair hearing. And he has been impeached. In my view, after that finding, the inevitable conclusion should have been to annul that impeachment. Why do I say so? Sometimes the argument I saw in the judgment is that acts the process has proceeded. A new deputy president has been appointed. You can't reverse some of those acts. If I recall, in Gachagua's petition, he actually said, look, he doesn't want reinstatement as the deputy president. He made it very clear to the court. So, when a right to a hearing is sacrosanct, the proper interpretation, in my view, is to annul what the Senate had done. And some of the provisions of our law are meant to be deterrent. Yes. If you allow this, that you can trample upon the rights of somebody, give him a few shillings, and the life continues. And particularly so when the 50 million is not coming from the pockets of the senators themselves. It is coming from the Senate. The fine or the damages were awarded against the Senate, not against the individual senators who actually voted for the impeachment. What is the effect of that? Government officers will continue violating the Constitution, knowing that they will not be punished individually. We will be entrenching the culture of impunity.